Welcome back to the deep dive. We've got quite a story to unpack today, based on sources detailing a really significant shift in labor and liability law.
Absolutely. And it's not just dry legal theory. This starts with a tragic real-world event that really forced the courts to rethink things.
Yeah, a high-stakes case. It brings up a fundamental conflict, doesn't it? What happens when an employee dies on the job, tragically, due to a random violent crime? Is the employer liable? How does that even work?
That's the core question, and this case really puts it under the microscope.
Okay, so let's get into the specifics. The case involves Romeo Ellao. He was 33, a company driver for Oceanmarine Resources Corporation.
Right, and this happened back in November 2011. His job involved driving around Pasay and Parañaque, making a series of company money withdrawals.
And during one of these runs, something horrific happened.
It did. While he was driving, two unidentified people on a motorcycle intercepted his vehicle. They shot him, killed him, and then stole the company money he was carrying.
Just awful.
Yeah.
And completely random, right? This wasn't about the employer's actions directly causing it.
Exactly. It's a violent crime, what the law often calls a fortuitous event. It happened while he was working, yes, but it wasn't, caused by employer negligence or anything like that.
And that distinction, fortuitous event versus employer fault, that's crucial here.
It's everything. Because after this tragedy, Romeo's common law partner, Jenny Rose Nedic, filed a complaint. She filed it for their minor son, Jerome.
And she wasn't just asking for standard death benefits, was she?
No, not at all. She sought P3,383,640.00. That's a huge sum. And the claim was specifically for lost future income.
Wow, okay, so that immediately takes it out of the usual workers' compensation framework.
Precisely. And here's the kicker. Her claim was based on Article 1711 of the Civil Code. This is an old provision from 1950.
Article 1711, what does it say?
It basically says employers are liable for the death or injury of their employees that arises out of and in the course of employment. Here's the crucial part. Even if it's accidental or due to a fortuitous cause.
So even if it's a random shooting, like in Romeo's case, this old article seems to pin liability on the employer.
That's exactly what it seems to say. And that's the conflict.
So our mission today in this deep dive is figuring out, how did the Supreme Court, in a 2022 decision, handle this massive claim based on an old, seemingly no-fault civil code rule, especially when we have the modern labor code specifically designed for workplace injuries and deaths?
Right. It's a legal puzzle that was decades in the making. To solve it, we first need to understand this historical tension, this sort of push and pull between two different ways of handling these situations.
Okay, so let's break down these two tracks. You mentioned compensation and damages.
Yes. Let's start with compensation. This idea goes way back originally to the Workmen's Compensation Act of 1927.
1927, okay.
The core idea there was no-fault liability. The thinking was, look, injuries happen at work. They're almost like a cost of doing business, a product of the industry.
So the employee gets paid something regardless of who messed up?
Exactly. A fixed amount, usually predetermined. It's meant to be relatively quick and certain. The trade-off is you get this fixed sum, but you generally give up the right to sue your employer for, potentially millions more.
Okay, that makes sense. But you said that system changed.
It did, big time. The old Workmen's Comp Act was replaced by the Labor Code in 1974 Presidential Decree 442. This created the State Insurance Fund, or SIF.
State Insurance Fund, how did that change things?
It shifted the burden. Instead of the individual employer being directly on the hook each time, all employers contribute to this state-run fund. It's based on the Social Security principle. The SIF pays out the fixed, no-fault benefits.
So it became a more collective system? The risk is spread out?
Precisely. That's the compensation track. No fault. Fixed benefits paid by the state insurance fund under the labor code.
Got it. Now what about the other track, damages?
The damages are totally different. This falls under the civil code think torts, or what lawyers call quasi-delict. Article 2176 is a key one here.
And how does that work?
It's all about fault. If you, the claimant, want damages, you have to prove that the employer was actually at fault. You need to show negligence or some breach of duty that caused the injury or death.
So much harder to prove, I imagine.
Definitely. It's a higher bar. But the potential payout can be much, much larger. Things like loss of future income, the kind of amount Nedic was asking for that's typically sought under damages.
Okay, so two distinct paths. Fixed, no-fault compensation via the labor code, or potentially huge fault-based damages via the civil code. Seems clear enough.
It should have been clear. But then, as you mentioned, the 1950 Civil Code threw a wrench in the works with Article 1711
Right, the article Nedic used, why was it such a problem? What made it so messy?
because it talked about employer liability for accidents, which implies no fault, but it was located in the Civil Code, the home of fault-based damages. It sort of blurred that critical line.
So it looked like a way to get civil code level damages without actually proving civil code level fault.
Exactly. Claimants started trying to use this Article 1711 to argue for big damage awards, like loss of future income, based only on the fact that the death or injury happened during employment, even for purely accidental or fortuitous events. They tried to bypass the whole proving negligence part.
That sounds like, well, an employer's worst nightmare, doesn't it? Automatic liability for potentially huge sums, even for things they couldn't control, like a random crime.
Precisely. And the courts really struggled with this over the years. There was a lot of confusion.
How did they try to sort it out initially?
Well, early on, like a 1971 case called Robles, the Supreme Court actually held that the compensation route under the old Workmen's Comp Act was exclusive, meaning you couldn't sue under the Civil Code at all.
Oh, so if that ruling had held up, Nedic's claim decades later would have been impossible from the start.
Correct. But that exclusivity didn't last.
What changed?
A really important case in 1985 called Floresca. Floresca basically abandoned that exclusivity idea.
Okay, so what did Floresca establish instead?
It introduced what's called the doctrine of election of remedies. This is super important. Floresca said the worker or their heirs have a choice
Choice
between claiming the fixed compensation under the Labor Code's state insurance fund or suing for potentially higher damages under the Civil Code, provided they can prove employer fault or negligence.
Ah, so you can choose your path, but
Yeah.
there's a catch, right?
Yes. The crucial part of the doctrine, you have to elect one remedy. You choose one path, and seeking relief under that path bars you from seeking relief under the other. You can't have both.
Okay, that makes sense. Pick a lane. Fixed and certain, or riskier but potentially higher reward if you can prove fault under the Civil Code, like Article 2176. That seems like a workable solution.
It should have been. But the confusion wasn't quite over yet, because Article 1711 was still lurking there in the Civil Code.
Right. And that brings us to another key case, the Candano case.
Exactly. Candano decided in 2007. This is where things went sideways again.
How so? What did Candano say?
Candano essentially seemed to affirm that this choice of remedies under the Civil Code still included using Article 1711.
Wait, so Candano said you could still use the no-fault logic of Article 1711 to pursue fault-based civil code damages.
That's how it was interpreted, yes. It effectively kept that problematic loophole open. Candano was read as saying, yes, you can sue for civil code damages like loss of future income, and you can base that claim on Article 1711, meaning you don't necessarily have to prove employer negligence, just that the death occurred during employment due to any cause, even a fortuitous one.
Wow. So Candano basically allowed claimants to, like, cherry pick the best parts of both systems. The potential for huge civil code damages, but using the easier no-fault standard from Article 1711.
That's precisely the issue it created. It undermined the logic of Floresca's election of remedies.
And that Candano precedent is exactly why Jenny Rose Nedic initially won her case at the Court of Appeals level, right?
Yes. The Court of Appeals explicitly relied on Candano. They said, look, Romeo died in the course of employment. Under Candano and Article 1711, the employer's obligation to pay indemnity, damage is automatically attached. Whether Oceanmarine was negligent or not didn't even matter under that interpretation.
Okay, so now the stage is set. The case goes up to the Supreme Court. They have this massive claim based on Article 1711, supported by the Candano precedent, but flying in the face of the modern labor code system and the Floresca choice. This is where it gets really interesting for you, our listeners.
It really is. Because in 2022, the Supreme Court took this Nedic case, Oceanmarine Resources Corporation v. Nedic, as the opportunity to finally decisively clean up this decades-long mess. They went straight for the jugular. Is Article 1711 of the Civil Code actually still valid law?
And what was the verdict?
A huge one. The Supreme Court declared that Article 1711 had been impliedly repealed by the Labor Code, specifically Title II, Book 4, which deals with employees' compensation and the state insurance fund.
Impliedly repealed. So the Labor Code didn't have a sentence saying Article 1711 is hereby repealed, but the court found they just couldn't coexist.
Exactly. The court gave two main reasons for this implied repeal.
Okay, what were they?
First, irreconcilable inconsistency. Article 1711, remember, makes the employer directly liable for the payment. But the Labor Code fundamentally shifted that liability for work-connected injury or death compensation to the state insurance fund. The court said these two approaches are fundamentally opposed. They're repugnant to each other. One centralizes liability in the SIF, the other keeps it on the individual employer. They can't both operate for the same situation.
Okay, that makes sense. The Labor Code created a whole new system that directly contradicts the mechanism in 1711. What was the second reason?
The second reason was coverage. The court reasoned that the Labor Code, being a later special law specifically addressing work-related compensation, was clearly intended to cover the entire subject matter. It was meant to substitute the older piecemeal approaches, including the one in Article 1711. The Labor Code provided the comprehensive framework moving forward.
So between the direct conflict and the Labor Code covering the whole field, the court concluded Article 1711 was effectively wiped out.
Yes, superseded. No longer operative law for claiming compensation or indemnity based merely on the fact an accident occurred.
Okay, if Article 1711 is repealed, what did that mean for the Candano Doctrine, the precedent that relied on 1711 to allow these kinds of claims?
The 2022 court was crystal clear and very direct about this. They explicitly abandoned the Candano Doctrine.
Abandoned entirely.
Entirely. They stated unequivocally that you cannot award damages based on an inexistent law. Since Article 1711 was deemed impliedly repealed, the Candano ruling, which allowed using 1711 as a basis for civil code damages without proving fault, was no longer good law.
So the message moving forward is, if you want civil code damages from your employer for a work-related injury or death,
You must prove employer fault or negligence under provisions like Article 2176 of the Civil Code.
Yeah.
The Article 1711 Candano shortcut is closed permanently.
this is a massive clarification, huge implications for employers and employees from 2022 onwards. But here's the twist that I think will really stick with you, the listener. If Article 1711 was repealed and Candano was abandoned, how on earth did Jenny Rose Nedic still win her multi-million peso claim in this very same 2022 decision?
Ah, yes. The final, crucial piece of the puzzle.
Huh.
Her victory hinges on a fundamental legal principle: the rule on prospective application of judicial decisions.
Prospective application, meaning it only applies going forward.
Exactly. The Supreme Court acknowledged, look, we are correcting a past interpretation of the law. We're setting the record straight now. But they also recognize that you can't unfairly prejudice people who acted in good faith based on the law as it was previously understood and declared.
So how did that apply to Nedic specifically?
Nedic filed her complaint way back in 2012. At that point in time, the Candano decision from 2007, even if later found to be based on a repealed law, was the final binding Supreme Court precedent on the matter. It was considered good law then.
So the court basically said, we can't fault her for using the law that we previously said was correct.
Precisely. Litigants and their lawyers have a right to rely on existing jurisprudence when they file their cases. The court cannot retroactively punish Nedic for following the prevailing Candano doctrine that was in effect in 2012.
So the abandonment of Candano and the confirmation of 1711's repeal, that applies only to cases filed after this 2022 decision became final.
That's right. For cases initiated before the finality of the 2022 Nedic ruling, if the facts warranted it under the old Candano interpretation, the claim could still succeed.
That's a fascinating application of legal fairness, even while correcting a long-standing error.
It is. So applying the now abandoned Candano rule to Nedic's specific situation, the court had to conclude that since Romeo's death clearly arose out of, and in the course of his employment, indemnity for loss of earning capacity was warranted under that now defunct precedent. She got in just under the wire, legally speaking.
Incredible. Okay, just a couple more loose ends to tie up. The employer raised another point, didn't they, about SSS benefits?
Yes, they did. Oceanmarine argued that Nedic had already received some benefits from the Social Security system SSS. I think it was around P36,000 for death and funeral benefits.
And the argument was?
The argument was that receiving these SSS benefits should trigger the doctrine of election of remedies. Choosing one path bars the other. So they argued she already got her compensation and couldn't now get civil code damages.
Did that argument hold water?
No. The Supreme Court shot that down. And this is another really important clarification for anyone listening.
Why? Aren't SSS benefits a form of compensation?
Not in the sense relevant to the Floresca doctrine. The court clarified that the election of remedies, the choice between labor code compensation from the SEF and civil code damages based on fault, only applies to those two specific paths.
So SSS is separate?
Completely separate. SSS benefits are paid out under the Social Security Act, RA 8282. This is social insurance. It's based on the member's contributions over time, matched by the employer. It's not directly tied to the cause of death being work-related in the same way SEF benefits are. Nor is it fault-based like civil code damages. It comes from a different law, a different fund, a different basis.
I see. So receiving SSS death benefits doesn't stop you from also claiming either state insurance fund compensation or suing for civil code damages if you can prove both. They're cumulative.
Exactly. SSS benefits are derived from the social insurance contract between the member and the SSS. They don't preclude claims under the labor code or the civil code. That's a vital distinction.
Okay, good to know. So finally, the money. The court upheld an award for Nedic, right? How did they calculate it now that they had to apply the Candano logic one last time?
They affirmed the award for loss of earning capacity and used the standard formula, often called the Villeray formula, to compute the exact amount.
Right, let's quickly break that down. Romeo was 33, earning P7,500 a month. How does the formula work?
Yeah, the formula is net earning capacity equals 23 multiplied by 80 minus the age of the deceased at death, multiplied by gross annual income minus reasonable living expenses. So
Okay.
plugging in Romeo's details, 23 times 80 minus 33 gives you the life expectancy multiplier, which is about 31 and a third years. You multiply that by his gross annual income, P7,500 by 12 equals P90,000, minus assumed living expenses, often pegged at 50% of gross income, so P45,000.
So 31.33 times P45,000.
It comes out to P1,410,000 Sarger. That was the final adjusted award affirmed by the Supreme Court.
And who gets that money?
The court clarified it goes to the heirs of Romeo Ellao, which is consistent with how damages are awarded under Article 2206 of the Civil Code. In this case, primarily benefiting his minor son, represented by Nedic.
So P1.4 million, awarded based on a legal precedent, Candano, relying on a statute, Article 1711, that the very same decision declared repealed and abandoned. Quite the legal outcome.
It really is a landmark case, illustrating both a major correction in legal doctrine and the crucial principle of prospective application.
So let's wrap this up. What's the big picture takeaway for the future? What does this mean now for employers and employees dealing with workplace accidents or deaths?
The main takeaway is clarity, finally. Article 1711 of the Civil Code is off the table for these kinds of claims. It's gone.
No more using it as a shortcut for damages?
Right. Claimants now face a clear, stark choice, the one intended by Floresca all along. Path 1. Claim fixed, no-fault compensation from the state insurance fund under the labor code. It's faster, more certain, but the amount is limited. Or Path 2. Sue for potentially much larger damages under the civil code. But, and this is the crucial but, now you must be prepared to prove the employer was negligent or at fault. No fault, no damages under this track. The days of getting potentially huge payouts for random, unavoidable workplace tragedies without proving employer fault are over.
That definitely simplifies the legal landscape going forward. So here's a final thought for you to chew on. We saw how the principle of prospective application saved Jenny Rose Nedic's claim here. She succeeded based on the old, now overturned Candano rule because she filed her case in time.
A critical point of fairness in the legal system.
But now that the law is crystal clear, employers are not automatically liable for damages just because a tragic, fortuitous event happens at work. How might this change things on the ground? Think about risk management. If an employer knows liability for big damages hinges entirely on proving their negligence, how might that incentivize or perhaps de-incentivize certain safety measures or insurance strategies compared to the old fear of automatic liability under Article 1711? That link between proven negligence and financial risk is now much sharper.
That's a really important question to consider. It shifts the focus squarely onto demonstrable due diligence and safety protocols in the workplace. Understanding this ruling is absolutely fundamental for navigating liability and compensation today.
Absolutely. A fascinating journey through legal history sparked by one tragic event. Thanks for joining us for this deep dive. We'll see you next time.